Welcome to the 15th year of the Willem C. Vis International Commercial Arbitration Moot. This is a dispute between Delicatessi Whole Foods and Comestibles Finos as a respondent. It's a dispute under the UNCITRAL rules before a panel of 3 esteemed arbitrators. In the chair, we have Andrew Aglionby, who is a long-time resident of Hong Kong, but has fairly recently, unfortunately for us, returned to London, where he is now an independent arbitrator. And to Andrew's left is Ariel Yi, who is a partner with Kingwood and Mallisons, and Ariel has recently come to Hong Kong to live, although she works in Shenzhen with King & Wood there. And to Andrew's right, we have Christopher To, who is a long-time figure on the arbitration scene, having been the head of the Hong Kong International Arbitration Center for several years before going on to other businesses in Hong Kong. And now Christopher is a barrister here in Hong Kong. Now, for the claimant, we have 2 excellent counsel teams. We have, for the parties, for the claimant, we have ILS Law School of Pune, India, and representing the respondent, we have Ludwigs Universität of Freiburg. And with that, I turn the microphone over to our chair and welcome you.
Lovely. Thank you very much. Well, we will get on with the main event without any further introductions. I understand the parties have had a chance to talk about the procedural order, and it's been agreed, as I understand it. So the respondent will commence on the procedural issues which are set out at procedural order number 1, paragraph 3(1)(a) and B. And the substantive issues, which are in the same paragraph but sub-numbers C and D, will then follow with the claimant going first on those and the respondent responding. And each speaker, as I understand it, is having 14 minutes with 1 minute reserved for rebuttal. Is that right so far? Yes. Okay. What about rebuttals? Have we discussed those? So we're having rebuttals? Yes, okay. So please keep time. You may have some questions from the tribunal, which may mean that your best laid plans are extended. If so, as you get to the end of your time, could you please ask for more time before your time has expired? Don't wait until after the time's expired to ask. And where you've been delayed by the tribunal, we're very likely to be able to give you some more time. Are there any questions about the procedure to follow? Are there any other questions? No, well, let's get on then. So I believe we turn to the respondent, who's got some submissions to make on procedural matters.
Yes, thank you, Mr. Presiding Arbitrator, members of the Arbitral Tribunal. To my right is my co-counsel, Mr. Alexander Koch, and my name is Yannick Jeremias. Together, we represent the respondent in this case, Comestibles Finos Limited. Members of the Tribunal, the matter we are dealing with today is one of very sensitive nature. Not only, and my co-counsel will speak on this, do we have to discuss that claimant delivered unsustainably produced chocolate cakes and thereby violated the core values of our client's code of conduct. But what's more, we are faced with the difficult situation that claimant appointed an arbitrator, Mr. Prasad, who is heavily entangled with claimant, claimant's counsel, and claimant's funder, and should therefore not act as arbitrator in these proceedings. In regard to this procedural matter, we make 3 submissions on behalf of our client. First, the Arbitral Tribunal should decide on the challenge against Mr. Prasad. Second, Mr. Prasad himself should not participate in the decision on the challenge. And third, Mr. Prasad should not act as arbitrator in these proceedings at all. Starting with our first submission, the Arbitral Tribunal should rule on the challenge against Mr. Prasad. In their arbitration clause, the parties agreed to settle any dispute without the involvement of any arbitral institution. And by this modification, the parties excluded the use of the appointing authority and consequently the application of Article 13, subsection 4 of the ancestral arbitration rules. When the parties first met, our client explained to claimant that it had been targeted in a negative press campaign for information that had been most likely leaked by an individual working for an arbitral institution. To avoid a similar leak in the future, the logical consequence was to only involve as few persons as possible in future arbitrations. And for that reason, our client switched to the ad hoc arbitration clause as it is today. In contrast to keeping the arbitration proceedings at the utmost level of confidentiality, the use of the appointing authority would introduce additional persons into the arbitration. And therefore, from the very start, it was unthinkable that our client would agree to the use of the appointing authority. The alternative, the designation of the appointing authority by the Secretary General of the Permanent Court of Arbitration, was likewise not an option for the parties, because they agreed to settle the dispute without any institutional support. And in light of this history, the arbitration clause bars the use of the appointing authority and consequently the application of Article 13, subsection 4 of the ancestral arbitration rules. As a result, the parties lack a procedure for challenging an arbitrator. And in that case, the lex loci arbitri, the Danubian arbitration law, becomes applicable. It is an adoption of the ancestral model law on international commercial arbitration, and the respective norm therein is Article 13, subsection 2, which provides that the decision on the challenge of an arbitrator shall be made by the arbitral tribunal. Therefore, to conclude our first submission, this arbitral tribunal should rule on the challenge against Mr. Prasad.
So can I just ask a question about your submission? You say 13.4 is excluded.
Yes.
But there's no wording you pointed to which sets out an express agreement that refers to the exclusion of 13.4. Your whole submission is about confidentiality. Is it possible to maintain confidentiality in some other way by perhaps making applications which are to named individuals or where the names of the parties are anonymized or something of that sort?
Theoretically, it would be possible that an individual could act as the appointing authority. But our client explained to the claimant that it had the fear that one individual leaked information to a competitor, and this resulted in a considerable drop of our sales. And because of this fear, also the use of an individual as the appointing authority was excluded. As to your question if the parties' names could be anonymized, if the Secretary General of the Permanent Court of Arbitration is requested to designate the appointing authority, the notice of arbitration and the response to notice of arbitration will be submitted to the Secretary General. And it is important that he knows about some matters of the substance of the case so that he could pick an arbitrator for the appointing authority that had knowledge and competence in the field and could therefore make the right decision for the decision on the challenge.
So does that mean that it could be anonymized or it couldn't?
We are not exactly sure if that will be a possibility, but the Secretary General will need information on this matter, and as he has a staff behind him and a bureau, an office of employees, as he cannot make every designation of the appointing authority by himself, this information will be aired within his office, and therefore this is similar to the structure within an arbitral institution, the exact thing that we expressed wanted to exclude from these proceedings.
Thank you.
Moving on to our second submission, Mr. Prasad himself should not participate in the decision on the challenge. Mr. Prasad would sit among this arbitral tribunal and assess the grounds of the challenge against himself. He would be a judge in his own cause, and as such he could never make a completely objective decision in the question. And in fact, this denies our client the opportunity to fully present its case in accordance with Article 18 of the ancestral model law. The arbitrator's lack of impartiality effectively denies the challenging party the opportunity to persuade that arbitrator of its case, and hence the other arbitrator's views during deliberations. And therefore it is our submission that the remaining 2 arbitrators should decide on the challenge against Mr. Prasad.
Can I clarify? In terms of, you're saying Mr. Prasad will not participate in the decision-making only, but he can actually participate in terms of giving support to the tribunal, in terms of giving information to the tribunal, because you're trying to challenge Mr. Prasad. So he has a right to represent himself, does he not?
That is correct. In case the other 2 arbitrators decide, which they should, then Mr. Prasad still has the right to be heard, similar to like a witness would be heard, but he should not be participating in the deliberations themselves because he has an interest in the subject matter.
Do you have any case of precedents or case to back you up in terms of an arbitrator, when challenged, should not participate in the decision-making process?
We do not, because we acknowledge that most of the countries that adopt the ancestral model law include the challenged arbitrator in the decision. However, in this case, we are talking about the Danubian arbitration law. And in Danubia, there is no precedence whether the challenged arbitrator is included and excluded in this decision. And opposing counsel might argue that in Danubia too, we should include the challenged arbitrator because of the legislative history of the provision Article 13, subsection 2. But in this legislative history, and I would like to quote from this in paragraph 45, it was stated that the chairman said that there was a general feeling that the challenged arbitrator should remain and thus rule on the challenge. If there were no comments, he would take it that the commission agreed on that point, and then in paragraph 46, it was so agreed. So this shows that this is only the general feeling that led to the inclusion of the challenged arbitrator, and for that reason, we can very well deviate from this interpretation in Danubia.
Can I just pick up on that point? So ignoring the discussion about the model law, but turning to the provisions of the model law, if one looks at 13.2,
Yes.
it refers to the arbitral tribunal making the decision.
Yes.
It doesn't refer to the arbitral tribunal less the challenged member, which it could have done. So what are we to make of that reference to the arbitral tribunal?
The reference to the arbitral tribunal, it is correct, it says the arbitral tribunal. But the arbitral tribunal, in our case, would be a 3-member panel. But impliedly, this means that 3 independent and impartial arbitrators should make any decision. And in our case, we would have one of the arbitrators that has an interest in the outcome of the decision and therefore already pre-made his mind on this.
Yes, I see. So you're interpreting it against the other comments that you've already made. But in 13.3 as well, while the challenge is pending, the arbitration can continue, and 13.3 specifically says that the challenged arbitrator can continue to participate. So what should we make of that express comment that allows the arbitrator to participate in the context of this challenge?
Article 13.3 of the model law was a very disputed provision when it was introduced. And there were voices that stated that if the state court makes the decision, during that time the arbitration should be put on hold. But then they decided to include the challenged arbitrator in the further decision and let the arbitral tribunal continue so that the arbitral proceedings and the efficiency and speed of the arbitration would not be delayed. And the fact that in this provision expressly states that the challenged arbitrator is included is the result of the compromise that the working group had made because of the propositions that the arbitration should be put on hold. But this does not say that in Article 13.2 the arbitrator could not be excluded from the decision.
Well, that might be the history, but how does that help us to decide? Because we've still got this wording in the law.
Yes, and all this shows is that if it does not expressly say if he's included, the challenged arbitrator, or excluded, that it is up to interpretation of the applicants of the law whether the arbitral tribunal is to decide in full or with the 2 remaining arbitrators, because this is a different situation than from usual decisions. Moving on to our third submission, Mr. Prasad should be removed as arbitrator because there are justifiable doubts as to his impartiality and independence. The standard for challenging an arbitrator is Article 12, subsection 1 of the UNCITRAL arbitration rules. And before I address the grounds of the challenge, I would like to start with an overview on the involved parties. First, we have Mr. Prasad, claimant's appointed arbitrator. Then there is Finefunds LP, claimant's third-party funder, which previously appointed Mr. Prasad. Then Mr. Prasad has a partner in his law firm who is representing a client funded by, yet again, Finefunds LP. And there is claimant's counsel who deliberately tried to hide those connections from the arbitral tribunal. Therefore, I would like to focus on two main areas of concern. First, Mr. Prasad's partner's connection to Finefunds LP, and second, Mr. Prasad's previous appointments. Starting with Mr. Prasad's partner's connection to Finefunds LP. In a pending case, Mr. Prasad's partner is representing a client funded by Finefunds LP, and Mr. Prasad is a named partner in his law firm, and therefore has an interest in the well-doing of the entire firm. The worth of Mr. Prasad's partner's case will be at least 1.8 million US dollars, and therefore Mr. Prasad has an incentive for keeping Finefunds LP as a future client. And one way to do so could be to render awards in favor of the funded parties, in this case, the claimant. This brings me to the second area of concern, Mr. Prasad's previous appointments. This is now the fifth arbitration in which Mr. Prasad has been appointed by either claimant's counsel or parties involved with Finefunds LP. And Mr. Prasad makes up to 8% of his annual turnover from those previous appointments involving Finefunds LP. And therefore, he might feel inclined to vote in favor of the funded parties to secure yet another reappointment. We are convinced that each of these situations already justifies a challenge to Mr. Prasad. But if this were not enough, claimant's counsel tried to hide these connections from the arbitral tribunal. And this shows that claimant's counsel was aware that these circumstances might impact Mr. Prasad's impartiality and independence to act in this case. To summarize, each of these situations should disqualify Mr. Prasad as arbitrator. But we urge the arbitral tribunal to consider the whole picture and see the pattern involving Mr. Prasad, claimant, claimant's funder, and claimant's counsel. And it is for this pattern that Mr. Prasad should not act as arbitrator in these proceedings.
Can I get a clarification? You mentioned about the prior appointment in the previous cases. And can you clarify that what's the bearing of those prior appointments? Because if you look at the procedure number 2, you're talking about in those prior appointments, the decision made by the tribunal, the other tribunals, are unanimous, which means Mr. President only play a part of it. Whether that piece of information has any bearing in terms of your challenge.
Yes, I see that my time has expired. I would like to answer your question if I may ask for additional time to do so.
How long?
I would take 1 minute and afterwards conclude.
Yes, surely.
Thank you. So as to the unanimous decisions, those were in 4 cases, and 4 cases do not bear a statistic weight for our cases. And the important thing is that even though Mr. Prasad voted in line with the other arbitrators, together with the previous appointments and his connections to Finefunds LP via the partners case, there is a financial dependency of Mr. Prasad on Finefunds LP, and for this he should not act as arbitrator in the current case. To conclude the argument, the arbitral tribunal should rule on the challenge against Mr. Prasad without Mr. Prasad participating, and it should remove Mr. Prasad for justifiable doubts as to his impartiality and independence. Thank you.
Can I ask you a question? You keep on referring to Article 12.1,
Yes.
impartiality or independence, but you keep on saying impartiality and independence. Impartiality and independence is a higher threshold, but the rules only say or. Can you elaborate on that?
Yes, this actually helps our case because it suffices to show justifiable doubts as to one of those attributes. And what we see in this case is a financial dependency of Mr. Prasad on Finefunds LP, and therefore it is already established that Mr. Prasad cannot act as arbitrator. Whether or not he is truly impartial is probably not the direct question here, and we do not question Mr. Prasad's integrity in these proceedings, but we still think that he should be removed because our client has justifiable doubts, and the other client, the other party probably has justifiable doubts because they hid those connections from the arbitral tribunal, and therefore a reasonable third person would have justifiable doubts as well.
Can you just help me with this word justifiable? Because there's a situation where you can have some doubts, but they might be fanciful. And then there'd be the opposite end of the spectrum, where you could prove that your doubts were real because there was some evidence. So you're in the middle, and you're saying the overall circumstances, the two in particular that you've mentioned, the subsequent amalgamation of the firm, and so his new partner's continuing dealings and his previous dealings are enough. But I'm not quite sure I understand why they're enough. Is it simply because there are now 5 or 6 different possible items? Is it a numbers analysis, or is there something else in the conduct somewhere, or in the relationship somewhere which you rely on? Perhaps you could help me with this point.
Yes, it's not a mere question of mathematical addition, that is correct. But what is always the question is where the money flows. And in our case, the money flows from Fine Funds LP via various connections, may it be the partner's case, may it be previous appointments, to Mr. Prasad. And because of this, Mr. Prasad has an interest in keep this flow of money to himself and vote in favor of the parties that are connected to Fine Funds LP. And this, in our case, is the claimant.
So, wouldn't the circumstance you're describing apply in many, many different relationships, though? Because you might have some tangential interest in lots of things. You know, a minor shareholding, for example, in a public listed company is another example that often comes up. When you rely on the justifiable wording, who has the burden? Which party has the burden of demonstrating that it's justifiable?
In this case, that would be us. And in this case, we are not talking about minor shareholdings. The lowest shareholding Fine Funds LP has in its subsidiaries is 40% in funding aid the partner's case. And the 1.8 million US dollars and the repeat appointments, though this money is of significance to the other party and to Mr. Prasad, and therefore Mr. Prasad has an interest that is above the threshold of a reasonable third person's thinking of justifiable doubts.
All right. Thank you very much. Are there any other? No. Thank you.
Thank you.
So perhaps we can turn for your response.
Good morning, members of this tribunal. I am Alifia, along with my colleague Yalini, appearing for the claimant's Delicacy Whole Foods, who is the seller of chocolate cakes in these proceedings. As an environmentally responsible company, my client made best possible efforts to sustainably source all its raw materials. In spite of being defrauded by our suppliers, we did not compromise on our relationship with the respondent. However, they wrongfully terminated the contract by imposing onerous obligations on us. Furthermore, they have also raised several challenges against our party-appointed arbitrator, Mr. Prasad. The two procedural issues that I will therefore be dealing with is firstly, the decision on challenge must be rendered by the appointing authority, and that in fact there do not exist any justifiable doubts as to Mr. Prasad's independence or impartiality. The respondent has firstly contended that the decision must be rendered by this tribunal. However, contrary to their submissions, the requirements of Article 8 of the CISG are not fulfilled because their confidentiality concerns and intention to modify would not have been understood by my client or any reasonable person. If I may firstly turn the attention of the tribunal to page 41 of the record to buttress my submission.
Okay.
Page 41 of the record, the fourth paragraph, last few lines. Mr. Arbitrator, if you are with me.
Yes.
In this witness statement, Ms. Ming makes it clear that while expressing her concerns with institutional arbitration, she went into the nuances and precise channel of that institution through which the information had leaked. Furthermore, it is our submission that my client therefore understood the respondent's concerns to be therefore limited to arbitration institutions per se and not third parties in general, such as the appointing authority. This understanding of my client was reaffirmed on page 8 of the record when the respondents wrote to us once again. This is page 8, the last paragraph, second line, where Ms. Ming once again stresses that our arbitration clause excluding institutional arbitration, stressing once again on only her concerns with arbitration institutions. Even if the respondents were to contend that the involvement of the Secretary General of the Permanent Court of Arbitration would be akin to institutional involvement, we submit that the same is not true for two reasons. The first is that in the event the parties cannot agree on an individual as an appointing authority, the Secretary General of the PCA can always designate an individual for the parties. Furthermore, members of the tribunal, if I may direct your attention to the confidentiality clause in this contract on page 13. In the third paragraph of the confidentiality clause on page 13, the last few lines, it is evident that the confidentiality clause provides an exception. Madam Arbitrator, if you follow, this is page 13, third paragraph, last few lines. We submit that what is provided is that in order to protect or pursue a legal right in bona fide legal proceedings before any court or arbitral tribunal of competent jurisdiction, which means that even the confidentiality clause of the respondents themselves allows for certain outside support in terms of the appointing authority for the purposes of legal proceedings. And therefore, even on a joint reading of the contract, my client could not have been aware that even within legal proceedings, the respondents wish to control the transmission of information.
So can I just check? So you would say that an application to an appointing authority fell within the exception?
Correct, Mr. President.
Within the wording bona fide legal proceedings before any court or arbitral tribunal. So what would it be? Would it be a court or an arbitral tribunal, the appointing authority?
Mr. President, we submit that legal proceedings before any arbitral tribunal, as envisaged in the clause, encompasses the entire legal proceeding, including challenges against arbitrators. And therefore, the appointing authority who becomes involved under Article 13, Subclause 4 in challenge procedures would fall within legal proceedings before an arbitral tribunal.
Thank you.
Moving on, members of the tribunal, if I may also turn your attention to the arbitration clause itself on page 12. This is clause 20 on page 12. There are two modifications in this arbitration clause which we did in fact understand. The first is the last line of the first paragraph, where the respondents explicitly excluded the UNCITRAL rules on transparency. Furthermore, in subclause A, the second modification is that in addition to the party-appointed arbitrators, the parties themselves can appoint the chairperson. Now, members of the tribunal, any third modification we would have been expected to be worded in a similar language, and therefore we would have expected that the appointing authority be excluded in a similar wording. And this is in consonance with the case of Econet Wireless versus First Bank of Nigeria, where it was held that absent intention of modification, substantial wordsmithing of the clause becomes necessary to give the modification any effect. However, without prejudice to this argument, even if the arbitral tribunal were to decide on the challenge, it must do so with the participation of Mr. Prasad. The two conflicting principles that the tribunal will have to balance in this case is that of nemo jude, as the respondents have raised, and the conflicting principle that we submit is due process as to the number of arbitrators the parties had agreed on. And we submit that even though the respondents have contended that it was only a general feeling in the drafting history that the challenged arbitrator must participate in the decision making, even the drafters believed that there would be no breach of the principles of natural justice, and this is for two reasons. The first is that the unchallenged arbitrators can always override the vote of the challenged arbitrator, and the second is that the decision is also subject to challenge if the need may be necessary.
Can I just ask a question there? So, yes, it might be 2-1, but isn't the point that there's an interest, Mr. Prasad has an interest which he can represent in the deliberations of the tribunal, and the fact that he might be outvoted doesn't take away from his ability to influence. And isn't it the ability to influence that's really under attack here? What do you say about that?
Mr. President, we agree that there are conflicting principles at play here. And the only way to overcome this conflicting principles and acquire a balance is to understand which of the two principles are safeguarded. And we know that the principle of natural justice will be safeguarded even if it may be at a later stage. But my client's agreement as to the number of arbitrators will not be. And Article 29 of model law envisages that all decisions must be rendered by the entire tribunal. Mr. Prasad's exclusion, therefore, will contradict not only the parties' agreement, but also the applicable procedural law. The second issue, therefore, before the tribunal is that there in fact exists no justifiable doubts as to Mr. Prasad's independence or impartiality. Because the connections and circumstances that the respondents attribute to Mr. Prasad normally exist in the international arbitration arena.
Can you elaborate on that? Normally exists in the international arbitration arena?
Yes. Mr. Arbitrator, we submit that repeat appointments, connections with parties, and all other such professional relationships will exist in a close-knit arena such as the international arbitration arena. And for the respondents to succeed in their challenge, the mere semblance of relationships is not adequate. They need to establish that there are extraordinary circumstances at play here, in addition to the normal relationships that we submit exist.
I understand the theory. Do you have any case law, anything to back you up in terms of this area?
Yes. Mr. Arbitrator, cases dealing with challenges such as that of Vivendi, Tidewater, all have held that there needs to be a proximity, intensity, and materiality of relationship for a challenge to be upheld. And we submit that the first conflict that the respondent did raise with reference to Mr. Prasad's law firm's connections falls on these grounds. For three reasons. Now, they submit that Mr. Prasad's law firm's connections with Funding 8 in another arbitration affect his impartial judgment in this arbitration being funded by Funding 12. Now, while Funding 8 and Funding 12 may have a common parent, that is fine funds, the natural oneness of these entities cannot be presumed, especially because fine funds does not even hold a majority share in Funding 8, which is the relevant subsidiary corporation for our analysis. Furthermore, there is a lack of a financial benefit as well. And for this, if I may turn the attention of the tribunal to page 50 of the record, this is procedural order 2. Question number 6.
Yeah.
Now, it is evident that the financial benefit that Prasad and Slowfoot derived was 1.5 million, and that accounts for 5% of the firm's annual turnover. The outstanding $300,000 therefore, if we do a mathematical calculation, amounts to only 1% of that annual turnover. After the merger of Slowfoot with Mr. Prasad's firm, since Mr. Prasad's annual turnover will become relevant, the outstanding $300,000 further falls to less than 1%. In addition to the fact that the financial benefit will be divided amongst 20 equity partners. And therefore, we submit that this amount is inconsequential to Prasad and Slowfoot's scale of operation and billing. Furthermore, in the case of Vivendi, when a significant commercial relationship was being looked at, what the tribunal held was that because the second arbitration was at a near end and there was inconsequential amount of work remaining to be done, there was no significant commercial relationship.
Can I just ask you a question? I'm just looking at it from a layman's point of view. If someone invites you for lunch, dinners, or goes on an aircraft or a yacht and all that, you're not getting any money. But wouldn't there be an implied sort of favoritism towards one person if they keep on inviting you for lunches, dinners? There's no money gained.
I understand, Mr. Arbitrator, and what you did in fact stress on is that when they repeatedly invite you for those lunch and dinners. But in our case, this is the first time that Slow Food ever used a third-party funder, which means that there are in fact no previous connections so as to then result in relationships of loyalty or even familiarity. Given the absence of those proximate links, there would be no appearance of bias or even justifiable doubts. Considering I have only a minute left, members of the tribunal, I will wrap up with the second and third conflict. But before
But before that, you were talking about find funds being in some way remote, as I understood your suggestion. Is that really accurate? I mean, don't they stand to benefit, even if it's indirectly, through the benefit that their subsidiary gets, potentially if they win, and then that would be passed in some way to the parent? So is it realistic for us to look at this as if the intervening Funding 8 and Funding 12 were unrelated in some way?
Particularly you mentioned about the use of special purpose vehicle, which is, the management will be the same, they set up the special purpose vehicle, particularly for one case. So therefore, to our mind, it could be that, they have, central control.
Members of the tribunal, if I may extend my time by 1.5 minutes to address both questions and wrap up.
Yes.
Thank you. To firstly answer your question, Mr. President, we submit that for the purposes of analyzing this conflict, we should not be bound by the structure of these corporations. Because for the purposes of this analysis, what needs to be looked at is how Mr. Prasad is connected to find funds and whether that relationship will then affect his impartial judgment in our proceeding, irrespective of what find funds or its subsidiary corporations are to gain. Because even if they may be gaining, say, 60%, if Mr. Prasad is in no way connected to these corporations, he will still remain independent and impartial. Furthermore, Madam Arbitrator, it is wrongful to contend that the subsidiary corporations are special purpose vehicles, because special purpose vehicles do not have decision-making capacity of their own, which the subsidiary corporations in our case in fact do. And if I may turn your attention to Procedural Order 2 once again on page 50 for the same. This is the fifth question, members of the tribunal, where the second line states that negotiations with find funds and then Funding 12 Limited, which means that even the subsidiary corporations are involved in negotiations with the potentially funded party and therefore have decision-making capacity of their own. In conclusion, members of the tribunal, we submit that even the repeat appointments are inconsequential because Mr. Prasad has been appointed as an arbitrator in 21 other arbitrations, which means that he maintains an independent source of appointments and is not financially or professionally dependent on the appointing parties. And to address your concern in specific, Madam Arbitrator, in the case of Vivendi, it was held that where the arbitrator has in fact rendered unanimous awards in those previous arbitrations, it goes to reinforce his impartiality. And therefore, we submit that given that these are only professional relationships and have not crossed those boundaries or thresholds, The challenge must be dismissed. If there are any further questions.
No,
Thank you.
Thank you very much. So, a rebuttal.
Thank you, members of the Arbitral Tribunal. Opposing counsel argued that the parties allowed for the involvement of the Secretary General of the PCA with the arbitration clause. But just in the clause before that, the parties' arbitration clause, the parties set forth the one requirement that was very clear from the beginning, that no institutions should be involved. Now, just in the clause, right behind that arbitration clause, our client allegedly allowed for the involvement of an institution. This cannot hold true, and therefore the Secretary General was excluded from these proceedings. Thank you.
Thank you. Is there a rebuttal?
We reinforce our submission, members of the tribunal, that involvement of the Secretary General is not the involvement of an arbitration institution, which is only what the arbitration clause excludes. It did not exclude anything else because my client never agreed in doing so. And therefore, where the Secretary General appoints an individual as an appointing authority, it would not fall foul of the arbitration clause.
All right. So I think in rebuttals, it's probably best only to answer new points. But I understand that's the submission you made before as well. So thank you very much. That's very helpful. So I think, don't we stay with the claimants for the submissions on the substantive points now, please? Thank you.
Good morning, members of the tribunal. I am Yalini, and I will be dealing with the merits of this case. The respondent contracted with my client through a tender process for the supply of chocolate cakes. And in spite of fulfilling all our obligations under this contract, they unfairly terminated this contract and have not paid the price for 600,000 cakes delivered. We will be contending before this tribunal that my client is only bound with an obligation of best efforts and has therefore delivered conforming goods on two grounds. Firstly, because this contract is governed by my client's standard conditions, and secondly, even if the respondent's standard conditions were applicable, they only oblige an obligation of best efforts and not one of guarantee. With respect to my first contention, I'd like to draw the attention of the tribunal to page 16 of the record. Page 16 contains the sales offer that my client sent in pursuance to the respondent's invitation to tender. If the members are with me.
Yes.
In the last few lines of this sales offer, there is a clear and explicit reference to the fact that the above offer is subject to the general conditions of sale and codes of conduct of my client. Such an explicit reference has been held as sufficient incorporation in the cases of pitted sour cherries and in Gantry versus Research Marketing Consulting. This reference is also supported with a link in the next line itself, where we refer the respondents to our website to find these codes of conduct and general standard conditions.
Yes, while we're on that page, just above the words you just referred to, there's a heading, specific terms and conditions, and a notation that says not applicable. And I suppose the other side might say there's a history with their tender, their conditions. The special terms and conditions were your chance to say, actually, we don't like that one, let's have something else. And you specifically said not applicable. So when looking at the intention of the parties, then it's not enough to say, oh, well, you know, for the first time we're going to introduce a whole new set of documents, the general conditions of sale. So when looking at the intention of the parties, what do I make of these words, not applicable?
Mr. Arbitrator, to answer that question, I'd like to direct the attention of the tribunal to page 53 of the record, Procedural Order 2, question 28. Here, in this question, it's detailed what the sales offer is constituted of. Members of the tribunal, this is page 53 of the record. Paragraph 28. If I may now direct your attention to line 4, the last two words. In case the claimant wants to make its offer subject to specific conditions which deviate from my client's standard conditions, we insert them there. Since there were no deviations that we intended to make from our general conditions, not applicable is how we would word such a condition as well. Moreover, Mr. Arbitrator, given that there were only 3 lines and given this, that Ms. Ming actually read this last few lines, and this is evidenced on page 17 of the record, where she states in the second paragraph, the 3rd line, that she visited our website following our tender. It means that she firstly read the first line, which is the incorporation clause. Then she in fact visited our website and saw these codes of conduct, and she had reasonable opportunity to access the general conditions as well. Moreover, if Ms. Ming wanted to reject these, she had an explicit duty to do so, as has been held in the case of INTA versus Officina Mechanica. It's also a fundamental principle of law that when offered certain terms that you do not want to be bound by, it's the duty placed on the offeree to explicitly reject these terms. Given that Ms. Ming acknowledged...
What about in Ms. Ming's letter? She talked about she downloaded this out of a curiosity.
Madam Arbitrator, we'd contend that Ms. Ming, being the head of purchasing of a high-level gourmet supermarket, is a commercially aware party, and she must understand the legal implications of her words in such an important document such as an award of tender. Moreover, given the fact that she has clearly read the last line, which subjects this offer to our general conditions and codes of conduct, and she did not explicitly reject it, we contend that incorporation of my client's standard conditions has happened successfully.
Can I just ask you a question? Like, when you're going to open a bank account and all that, and you're a professional person, do you really read the terms and conditions? Does the bank have to draw it to your attention?
Mr. Arbitrator, the bank does have to draw it to our attention, and in this case, we contend that we did draw it to their attention very specifically, merely because of the fact that Ms. Ming, while reading the offer letter, saw this website insertion, saw this incorporation clause. She read it, she had actual knowledge of it, and in pursuance of that, she visited our website.
Just assuming she read it, she might have just opened it and just not closed her eyes.
Mr. Arbitrator, here we'd like to draw as to how incorporation is to be made and what burden is placed on my client. The only burden that we have to discharge is to make sure that Ms. Ming had reasonable opportunity to read these codes and standard conditions, which she did. By insertion of the link and by her visiting the website, she had all the necessary requirements to make herself aware of the standard conditions and codes of conduct. Therefore, we contend that incorporation of my client's terms was done successfully. With respect to my second contention, we will be submitting to this tribunal that even if the respondent's standard conditions were applicable, they only oblige an obligation of best efforts and not guarantee. To determine what kind of obligation arises under the contract, we must look towards the unidroit principles, specifically Article 5.1.5, which lays down certain factors to be analyzed in this regard. The first one that I will be drawing upon is the contractual language present in this case. For this, if I may draw your attention to page 13 and 14 of the record, this is the code of conduct for suppliers for the respondents. They've terminated our contract specifically in pursuance with clause C and E of this code. If I may draw your attention to page 14 of the record, The third bullet point from the top, which is part of clause C, and the second bullet point in clause E are the only two clauses which bind my client and my suppliers. These terms and these obligations are inherently subjective and onerous obligations. They're also worded as such if you look at the language used in the third clause from the beginning, which states ensure that your own suppliers comply with the above requirements. Now, the word ensure has been interpreted in the ICC case number 9797 as best efforts to ensure. To buttress why this was termed in such a way, I'd like to direct your attention to the first clause in C, which you can find on page 13. The first one states formally appoint a competent person. It lays down clearly what the obligation is. It lays down a mechanism as to how this is to be fulfilled. If we refer to the second clause on page 14, this is also extremely clear as to what it expects. It states establish appropriate organizational structures. Now, this is in sharp contrast with the last two clauses in C, which state ensure all workers are sufficiently aware and ensure that your own suppliers comply with. Both these clauses are extremely subjective, and there is no possible way for a party to guarantee that these are complied with. Moreover, we'd like to point out to the fact that the risk involved in performance of these obligations is too onerous, and it's an extremely high-risk obligation, which then translates into an obligation of best efforts only. For this,
Sorry, so if it's a high-risk obligation, it's a best efforts, not a guarantee. Why is that?
Mr. Arbitrator, this is for the simple reason that a high-risk obligation or an onerous obligation cannot be guaranteed under any circumstances.
Well, is that completely right? Couldn't you agree? Couldn't parties agree that that was the risk allocation?
Mr. Arbitrator, if the respondents managed to discharge the burden that both parties did in fact agree on a guarantee, this will be, as you stated, imputed as a guarantee. However, when we're interpreting the contract under Article 5.1.5 of the UNIDWA principles, an onerous or a high-risk obligation cannot translate into a guarantee, as was held in the case of Australian Medical Care versus Hamilton Pharmaceuticals. And to buttress my argument with the intention of parties, I'd like to draw your attention to page 41 of the record.
I mean, here, aren't we dealing with a risk that's already adversely affected the respondent historically? And so they have every reason to try and manage that risk and every reason to pass the risk to another party. So I appreciate your submission that because it's a risk, maybe one should treat it with caution, but having treated it with caution, if there is an express term, wouldn't that still bind, or are you saying it would not bind?
Mr. Arbitrator, we'd contend that if there was an express inclusion added with intention on both sides, it might translate into a guarantee. But I will be now proving to you why we never assume that risk, and this intention as expressed by us and as understood by the respondents was only that of best efforts. For this, I'd like to direct your attention to page 41 of the record.
Okay.
Can I also maybe just go to page 41? I'm just reading the literal meaning of page 14. Bullet point 2, ensure that all workers are sufficiently aware of these risks and appropriately trained on the implementation of control measures. That's pretty easy to do, isn't it? You inform everyone and you make sure that they do everything properly. That's not really difficult.
Mr. Arbitrator, we contend that our duty does not end at informing everyone. The duty here is to make sure that our workers are sufficiently aware, not that we must inform them. And making sure that our workers are aware, we contend, is again an onerous obligation. And more specifically with respect to these obligations that bind my client and its suppliers, I'd like to point out to intention. And as I see my time is running out, may I ask for an extension of 1.5 minutes?
Yes, yes.
Mr. Yes.
Before we move on to the witness statements,
Just
the last point on the page 14, C, it said ensure your own suppliers comply with the above requirements.
Yes,
which
Madam.
is sort of the result driven. You need to do everything possible to ensure at the end of the day they comply with it.
Precisely, Madam Arbitrator. We contend that this was only for us to do everything possible, as was also held in the case of ICC 9797, as I previously pointed out. This is to make best efforts to ensure that our suppliers complied with this. And again, drawing to intention to buttress this questioning and to provide clarity to the tribunal, I'd like to point out to the witness statement of Annabelle Ming, who is the respondent's head of purchasing. On paragraph 3, the last line, we've stated that Ms. Ming understood that the code of conduct that the claimants had with their suppliers could only largely guarantee compliance with the code. Therefore, Ms. Ming knew that we, claimants, only had a best efforts contract with our suppliers. Given that we only had a best efforts contract, there was no possible way that we would undertake a guarantee obligation with the respondents, because it would amount to unfair risk allocation towards my client and expose us to liabilities such as these, which we never intended to undertake. This expression was also made clear to them in our sales offer, which can be found on page 15 of the record.
Can I just ask you, you're using the word best efforts, why not just reasonable efforts?
Mr. Arbitrator, we contend that my client also is an environmentally responsible company. However, we place greater reliance on the quality of our products and its taste rather than sustainable production. Therefore, we also believe that products must be sourced sustainably, and for this, we try to do everything possible to guarantee. I'd also like to point out to the fact that we have a very good control mechanism in place, which in no way could have in fact detected the fraud in this present case either. We had regular auditing requirements. We monitored our suppliers through questionnaires.
I think, I don't mean to cut off your submissions, but if we concentrate on the extent of the obligation rather than compliance with it, that's probably a good use of time. I've got a thought. There are two obligations. One's in your conditions, and it's a best endeavours obligation. And the other's in the respondents' conditions, and they say it's a guarantee. We'll hear from them. Why can't they both apply? Why isn't one simply a guarantee to do it, and the other is to use best endeavours to achieve that end?
Mr. Arbitrator, although that may be possible to contend, and they will probably contend that as well, however, we'd submit that intention of the parties is paramount here. Because if we never intended to undertake a guarantee with them, they cannot unfairly allocate all their risks to us and expose us to liabilities which were clearly outside our sphere of influence. Given that we could not possibly guarantee to them now stating that it was a contract of guarantee amounts to unfairness and an interpretation of the contract under Article 5.1.5 will also not lead to such a result.
So you're not saying that it would be inconsistent for there to be two obligations so that they'd conflict, but you're just saying we didn't agree to it, so it doesn't apply.
Yes, Mr. Arbitrator, we contend that contractual autonomy gives parties to contract in whichever way they like. But in the present case, and given the factual corners of this case, an obligation of guarantee was never accepted by the claimants, and this was communicated to them as well in our offer letter on page 15 of the record. While sending in our offer to them, specifically, we told them that we will only be able to do everything possible to guarantee and not absolutely guarantee. Lastly, members of the tribunal, to sum up, we'd conclude that the respondents are precluded from giving any suggestions now as to how this best efforts could have even been performed, because they were aware of all the activities that we were carrying out. They in fact visited our premises, they vetted our control mechanism and found it so impressive that they did not make any further visits or audits on my client. With this, we conclude that the respondents were unfairly terminated the contract, and they are liable to pay the price for 600,000 cakes delivered. Thank you, members of the tribunal.
Thank you very much. So, if I might turn to the respondent for your submissions on that point.
Thank you, Mr. Presiding Arbitrator, members of the tribunal. As already introduced, my name is Alexander Koch, and I will elaborate on the merits on behalf of the respondent. Our client is a gourmet supermarket chain that is well known for its sustainable products, and therefore it was very pleased when it found out that the claimant wanted to deliver a sustainably produced chocolate cakes. The parties concluded a contract, but contrary to opposing counsel's argument, under the application of the respondent's standard conditions. And these provide that the claimant has to guarantee the sustainability of the cakes. Yet, for the production of these cakes, the claimant used cocoa that was farmed under highly unsustainable methods, and our client therefore terminated the contract. Now, in order to deny its own responsibility, the claimant alleges that instead its own standard conditions govern the contract. This is, however, not true, and therefore I will make two submissions on behalf of our client. First, the respondent's standard conditions govern the contract. Second, under these standard conditions, the goods delivered by the claimant were not in conformity with the contract. Starting with my first submission, the respondent's standard conditions govern the contract. In order to be incorporated into a contract, standard conditions need to be first part of the offer, and this offer then needs to be accepted. In the case at hand, we do not dispute that the offer was made by the claimant and that this offer then was accepted by our client, the respondent. However, opposing counsel argued that this offer was subject to the claimant's standard conditions. For that, she relied on two requirements. First, she mentioned the reference to these standard conditions, and second, that our client must have had a reasonable, the client must have had a reasonable opportunity to take notice of these standard conditions. I will apply the same standard as well, but I will come to a rather different conclusion, as both of these requirements have not been met in the case at hand. So regarding the first requirement, the reference on the sales offer form. Yes, there is a reference to the to the standard conditions of the claimant. For that, opposing counsel submitted two cases that support her position. I would like to submit a case as well. This was the Rosa Technologies versus Kyle Schreiber Inc. case, and therein a similar incorporation clause was used. Let me quote that. This order confirmation is subject to our standard conditions of sale as known, and then a hyperlink to the website, but to the mere landing page. And the court in this decision concluded that the language included on the order confirmation was ambiguous at best, as the language merely directs the other party to a website which needs to be navigated in order for the standard conditions to be located. In the end, the standard conditions were not incorporated into the contract in this case. In the case at hand, it is the same, in particular because of two reasons. First, the parties agreed beforehand that the standard conditions of the respondent were to be incorporated in claimant's offer, and second, when the claimant then made the offer, it did not indicate a deviating intent. Regarding the first reason, the parties concluded the contract within a tender process. Yes. And a party usually starts a tender process because it already has a specific idea in mind about the content of this contract. For that, it drafts a set of tender documents with requirements that should then become part of this contract. And the parties participating in the tender then make proper offers containing these incorporations and requirements. Accordingly, in the case at hand, the tender documents of the respondent required the incorporation of the respondent's standard conditions. And now I would like to direct your attention to page 28 of the record. This is the letter of acknowledgement submitted by the claimant after it has received the tender documents. Therein, in point 3, it confirmed that it has read the invitation to tender and will tender in accordance with the specified requirements. In light of this clear statement, our client could reasonably expect the offer then to also contain the respondent's standard conditions.
So what meaning then do you give to the wording that says different standard conditions will apply? How do we interpret that wording?
We acknowledge that the incorporation clause is contained in the offer form, but we submit that within the cover letter that was sent together with the offer, the claimant made a deviating intent from that clear, and thus the incorporation clause remains with no effect. And for that, I would like to refer you to page 15 of the record, where this cover letter can be found. In this, the claimant explained that it had to make changes to these tender documents. And in the second paragraph, it noted these changes as being minor amendments relating primarily to the goods and the mode of payment. First of all, at no point in this letter did the claimant mention that it also intended to include its own standard conditions into the offer. And second, itself described these changes as being of a minor nature. We don't see how the exchange of a whole set of standard conditions, including the codes of conduct that are of utmost importance to both parties in the case at hand, can be considered a minor amendment. So the offer in itself is contradictory, and rather the cover letter describes that the claimant had no intent to incorporate its own standard conditions. And this is furthermore then confirmed if we look at page 16 of the record. The specific terms and condition part of the offer the arbitral tribunal already addressed. Therein the claimant stated that specific terms and conditions are not part of the offer and that this is not applicable. Now, from our client's perspective, this clause could only reasonably understood as a reference to the tender documents, and that to these tender documents there were no specific terms and conditions added. Therefore, also the claimant's standard conditions, which would have been specific terms, are not incorporated into the offer.
Could I ask you, if you look at page 17, the second paragraph, that's your letter, isn't it, your client's letter?
Yes.
It says here, you were impressed by the code of conduct and you downloaded and all that, so your client did look at the website and you did look at the terms and conditions. And why didn't you question, or your client didn't question the terms and conditions at the time?
To first answer your question, Ms. Annabel Ming herself stated that she has only read the codes of conduct out of curiosity. So this already shows that she did not deem them to be applicable to the contract, but rather looked them up out of curiosity. And second of all, it is our submission that the reason why our client has read these conditions is not important at all. First of all, our client only looked up the codes of conduct. However, the question at hand refers to the general conditions of sale. We don't even know if the general conditions of sale of the claimant are also accessible directly off the landing page Ms. Annabel Ming referred to, or if they need to be further navigated in the case at hand. And as Ms. Annabel Ming has only read the codes of conduct, the general conditions of sale were, to come back to the second requirement, not reasonably available to our client.
Sorry, can I, is there nothing in procedural order number 2 about the accessibility of the standard conditions from the landing page? I thought there was something.
This would be page 53 of the record.
Yeah.
Clause 28 again.
Yeah. The last sentence. Yeah.
Yes. And it states that the last sentence refers to the codes of conduct. Yes, these can be accessed directly from the landing page. However, the incorporation clause refers to the general conditions of sale, and we do not have any information whether the general conditions of sale can be directly accessed in a similar manner, or if there is further navigation needed for that.
Okay, thank you.
Opposing counsel then stated that our client had a duty to reject to these conditions when we accepted the offer. However, as the standard conditions were not even part of the offer, this duty does not exist for our client in the case at hand. Regarding the question Mr. Presiding Arbitrator asked the opposing counsel whether the case could be that both standard conditions apply. Indeed, if the arbitral tribunal were to find that the incorporation clause was sufficient to incorporate the claimant standard conditions, then we would have the situation that the claimant standard conditions are in the offer as well as the respondent standard conditions as they were attached. We then would have two contradicting standard conditions. On the one hand, the claimant standard conditions include a best effort obligation, whereas the respondent standard conditions include an obligation of result.
Do they really conflict? Because one is an obligation to do your best to achieve an aim, and you could breach that obligation by not doing your best, but coincidentally the aim might be achieved. And separately, there's a guarantee of the aim. So are they really conflicting?
I see a point, Mr. Presiding Arbitrator. I would like to answer this by referring to the aim of the knockout rule that is usually used to solve such a battle of form situation. In such a case, contradicting terms are knocked out of the contract. And the question then is, yes, are these terms contradictory? And the party that establishes a best effort obligation in its contract surely does not want to be liable if this result is not matched. So we have the case that on the one hand, a best effort obligation does not include a result, and the result, of course, includes the best effort obligation, but these are two different intents of the parties, and therefore, according to the knockout rule, these would then be knocked out from the contract. And in this case, the goods were also not in conformity with the contract, as we would then fall back to the applicable law, which is the CISG, and according to the basic principle of liability, of strict liability the CISG provides, the claimant did not deliver a sustainably produced cake, and therefore the goods were not in conformity with the contract. This would now also lead me to my second submission, that under the respondent's applicable standard conditions, the goods delivered by the claimant were not in conformity with the contract. Opposing counsel interpreted the contract following the guidance given by the unit droit principles of the Article 5.1.5. She referred to the language, the risk, and the risk involved in the case at hand. I will do that as well. First, regarding the language. Yes, we are talking here about the principles C and E of our client's code of conduct and the verbs ensure and make sure. Opposing counsel stated that these are extremely subjective and therefore rather indicate a best effort obligation. But, for example, if I may provide the tribunal with the definition under the the Cambridge Dictionary, ensure means to make something certain. So the verbs can be interpreted in both ways, and we do not move forward by just looking at these verbs. We much rather have to interpret the contract by looking at the bigger picture. And for that, I would like to refer you to page 12 of the record, where on the bottom of the page, clause 21, the confidentiality agreement can be found. And in the second paragraph, the claimant was required to quote that, undertake to keep confidential and to exercise their best endeavors to procure that such persons as may be under their control keep confidential. So what can we learn from that? Whenever the parties are actually required to use their best effort, it is explicitly stated in the contract. When we now look at the sustainability provisions and the specification of the goods, we will see that no explicit best effort clause or best endeavors clause is contained in there. So this rather indicates that in this regard, a result was required. This is furthermore not changed by the risk involved in the obligation. Opposing counsel referred to the risk and stated that such a large guarantee would be unreasonable and that therefore best efforts were rather required by the contract. However, in this regard, I would like to refer you to page 41 of the record. I see that my time has run up, so can I answer or conclude this argument and then wrap up?
Yes, take a further 2 minutes.
All right, thank you. In paragraph 3, first of all, this is a witness statement by Ms. Annabel Ming in which she describes a conversation she had with Mr. Kapoor Tsai at the Kusina Food Fair, and Mr. Kapoor Tsai is the head of production of the claimant. And when you look at paragraph 3, you will see in the last sentence that Mr. Kapoor Tsai itself acknowledged that the claimant at this point could largely guarantee compliance with the code by their suppliers. So the claimant itself acknowledged that the guarantee was possible to a large extent, and therefore it is not reasonable to then also be liable in case the guarantee is breached in this regard, as the compliance could already be guaranteed to a large amount.
Can I just make sure I've understood that submission? Because there's an absolute guarantee, so whether you're at fault or not, if the guarantee is not met, you're liable. And isn't that the large risk described? Then there's a best endeavours obligation, and you have a defence if you can say, well, we've done all that we could, and although it hasn't worked, we've complied with our obligation, and those are the two positions. But isn't this wording that you've just pointed to largely guarantee compliance? Isn't that more of a best endeavours wording than an absolute guarantee?
It is indeed our submission that the claimant at this stage already understood its obligation of being an obligation of guarantee. Therefore, the phrase used by the head of purchase in this regard rather indicates that the claimant understood its obligation as a guarantee, and the largely then refers to the possibility that at this point is already reached. And this is furthermore underlined by the phrase opposing counsel has already referred us to, that the claimant stated when making its sales offer. The claimant stated that it would do everything possible to guarantee the compliance of its suppliers. So it was aware of its obligation and wanted to do the best to also fulfill it.
But isn't the wording "do everything possible" a qualification on guarantee?
And also, what about they claim they are victims of a default?
Regarding the first...
criminal liability of third parties, whether that carry any...
Yes. Regarding the first question, you referred to the wording, will do everything possible to guarantee. We have to acknowledge here that a best effort obligation surely involves a lot less action taken by a party as everything possible. So everything possible is a lot higher than an actual best effort obligation, thus already indicating that a guarantee was required in this regard. Regarding the second question, whether the claimant was victim or not is irrelevant in the case at hand, because we are talking about a question of risk allocation. And under this contract, the claimant took the risk for the cakes being non-sustainable. And when that result is not reached, the claimant is liable, no matter if it was his fault or not. So to then wrap up my arguments, first of all, the respondent's standard conditions govern the contract. And second, under these standard conditions, the goods delivered by the claimant were not in conformity with the contract. Thank you.
No, thank you. Perhaps we can turn back to the claimants.
Two quick rebuttals to their submissions, members of the tribunal. Firstly, they've relied on the plain meaning rule of the contract, which is not allowed in the CISG. And the CISG always allows for intention to then interpret what clauses in the contract mean. And as we've clearly stated, and it was expressed by us and understood by them, that an only obligation of best efforts can be imported into this contract. They cannot now strictly rely on the wording of the contract. Secondly, opposing counsel made a statement that there's a difference between doing everything possible and best efforts, and that one standard is higher than the other. However, they've not given any authority to buttress this same. And under the UNIDWA principles, best efforts is defined as reasonable efforts as taken by a reasonable person in the same circumstances. With this, we'd like to conclude our submissions. Thank you.
Thank you. Is there a rebuttal?
Yes, Mr. Presiding Arbitrator, thank you. Regarding the first point, it is our submission that it already follows from the wording that best efforts, as described as as reasonable efforts as taken by a person in the relevant circumstances, and doing everything possible is a difference, and doing everything possible surely has a higher standard. Regarding the second point, no, all right, that's it. Thank you.
All right. Thank you very much, both parties, for their very helpful submissions. We're going to retire and discuss what we've made of it all, and we will have an announcement later. So I would just like to congratulate both teams. That that felt very real to us sitting here. You're absolutely in the right place in the final here. You're all justifiably in this competition and at this level. So congratulations to each and every one of you. That was excellent. Well done.
Well, thank you. And as Andrew Aglimi has said, the tribunal will retire, but we will also retire, and we will retire out these doors here. And we'll convene before noon. There is some time now. We've got, it's 11:20 now, so we have some time. And we'll reconvene outside where indicated for the group photograph. And remember, please take everything with you when you leave.